All right, this is Ricky,
And this is Brendan.
and you're listening to A Gentleman's Disagreement.
What I wouldn't give for the hope I used to find in a case of lion's head. Folks of different minds, because even though it did not share the pains we share, that American ideal, friends made over arguments in an early morning buzz. Need an early morning buzz.
All right, Brendan, it is July 15th, a Monday here in Boston. We're a couple weeks since our last recording, July 4th. Yesterday was Bastille Day for those who celebrate. And I don't know, it's obviously been an interesting weekend in politics as well, but it's good to see you again.
Yeah, good to be back. Did our little summer recess. We did, I think, 5 episodes in June. 5 really good episodes, in my humble opinion. Uh, totally unbiased. I don't know if you can hear the rain's finally rolling in, Ricky. We can hear the thunder outside, which is much needed up here in the Northeast. But I do want to kind of build off what you were just alluding to, where obviously we are well aware that the attempted assassination of President Trump is dominating the news cycles right now, as well it should be. Thrilled, I texted you after that, thank goodness, thank God that he wasn't killed, for many reasons. But I had a bunch of people reach out, Ricky, and ask. They were saying, I can't wait to hear the next episode of Gentleman's Disagreement about everyone's thoughts about this, which I always really appreciate. It's always like humbling and flattering when people are reaching out being like, I want to listen to what you guys have to talk about, which is, again, great. We're not going to talk about the assassination attempt and the fallout from that on this episode for a couple of reasons. One is that we had already planned on doing a different episode today that we had scheduled, and that episode is going to be a review of the Supreme Court's 2023-2024 term. We are really excited to welcome back onto the program Professor Renee Landers, who joined us back in the fall in October to do a preview of the term, and the term was even more explosive than we could have imagined at the time, given the Trump cases that the court heard after the start of the term. And then we'll also talk about the administrative law cases, the abortion cases, the gun cases. So we're going to try to hit all of that in what I'm looking forward to and hoping is going to be both an in-depth but also accessible conversation for people who are lawyers and scholars and non-lawyers, non-scholars alike. So that's one of the reasons. And the second reason is we've tried not to do like hot takes on these topics. You can get those in plenty of other places out there. There have been times where I get fired up, and I think you do too, and I'll text you and say, like, I was even after like the January 6th stuff, or obviously even this weekend, as we got to talk about this. And I think we try to do a good job of letting emotions cool a little bit and try to gather more information and read different sources and like let more information come out before we talk about it. So we will talk about it in next week's episode. We'll do it in conjunction with a conversation about the RNC and President Trump's vice presidential pick. And so I think there'll be plenty to talk about those issues, but we kind of felt we'd be remiss not to at least acknowledge and mention that this was a historic and significant incident that happened this weekend, and it's very much on our minds.
Yeah, definitely. But like you said, still piecing through it and sort of the implications and the fallout from it. So good for us to take some time to digest and really honestly looking forward to this discussion with Professor Landers.
Yeah, I think she is really like a perfect person to bring on, given how like admin law heavy and health law heavy this term of the court has been. I'm really hopeful that she's going to be able to illuminate some things for me, some of the complexities about these cases, and perhaps answer some of mine, hopefully yours and other people's questions about what these cases actually mean going forward. Before we bring her on, a reminder to everyone out there, the podcast is brought to you by the hardworking craftsmen over at Cannon Hill Woodworking. They've been building handcrafted, high-end custom tables and desks in Boston since 2018. That's Cannon with 2 N's. You can check them out on Instagram or visit them online at www.cannonhillwood.com. Ricky, we have the last golf major of the year coming up this weekend. It's always like a bit of a bittersweet time with the British Open. And Ricky, one thing I was thinking about is that a lion would never play golf, but a tiger would.
You should have known.
And I don't know how many left we're gonna have of Tiger actually playing. So I want to get that in while I could. Looking forward to watching that, and very much looking forward to this conversation with Professor Landers.
All right, bud. Let's get into it.
All right, we are now thrilled to welcome Professor Renee Landers back to the program. Professor Landers is a professor of law, the faculty director of the Health and Biomedical Law concentration, and the Masters of Science in Law Life Sciences program at Suffolk University Law School in Boston. Previously, she was the president of the Boston Bar Association, where she was the first woman of color and the first law professor to serve in that position. Professor Landers has also worked in private practice and served as the Deputy General Counsel for the U.S. Department of Health and Human Services, and also as the Deputy Assistant Attorney General in the Office of Policy Development at the U.S. Department of Justice during the Clinton administration. Professor Landers has also served as the Section of Administrative Law and Regulatory Practice of the American Bar Association, and she chaired that section's nominating committee. She is a trustee of the Massachusetts General Hospital and the New England Donor Services, and is a former trustee of Massachusetts Eye and Ear Infirmary. In 2019, she rejoined the board of Planned Parenthood of Massachusetts and became the president of the board beginning in July of 2020. She was also a member on the Massachusetts Commission on Judicial Conduct and served as vice chair of the commission from 2009 to 2010. She also served on the task force that drafted the revised Massachusetts Code of Judicial Conduct in 2016, and currently is a member of the Committee on Judicial Ethics, which advises judges on compliance with that code. In November of 2018, she was elected a fellow of the American Bar Association Section of Administrative Law and Regulatory Practice. This is a short piece of Professor Landers' bio, which is still quite lengthy and impressive, but I highlighted those particular things because I think all of those experiences are relevant to some of the case law that we're going to be talking about today. Professor Landers has also written numerous articles, served on numerous boards, and won numerous awards. Most importantly to me, she was my constitutional law teacher at Suffolk, and I'm thrilled that we've been able to continue the conversations that we've now been having for almost 4 years now, which has really been my pleasure. So, Professor Landers, thank you again for joining us today.
Oh, thanks so much, Brendan. And also, I think that my biggest qualification is being your constitutional law professor and sort of keeping me honest about all of these issues. So I appreciate also the ability to continue the conversation. I should have actually updated my CV, my bio a little bit, because I am no longer on the Committee on Judicial Ethics. I got term limited out earlier this year, and since it's the judicial ethics, I guess I should be ethical and declare that accuracy. And then on Planned Parenthood, I'm still on the board, but I'm no longer the board chair. But that's neither here nor there. Your points are well taken. Those are good examples of my experience that relate to this topic.
Yeah, exactly. And the term limits, what a concept. We appreciate you abiding by those. All right, so we talked back in the fall, and we had kind of said at the time that this might be a relatively quieter term compared to the previous 2 terms, where you had the explosive issues of guns and abortion and affirmative action. And so we talked about the administrative law cases, which we are going to get into, but really, I think this court is going to be defined by some of the cases that they took on later in the term, and this is in particular the two Trump cases. So the first of those Trump cases was Trump v. Anderson, which was whether or not the 14th Amendment disqualified President Trump from office, and Colorado had said that it did. The Supreme Court reversed in what was ostensibly a 9-0 decision, but was kind of more of a 5-3-1, a 5-1-3 split. But kind of the important takeaway from that was the court found that Colorado nor any state could disqualify a presidential candidate. Ricky and I did a deep dive on that back in January, but Professor Landers, I don't know if you had any kind of additional thoughts about that case.
No, I mean, I think that result, because that part of the decision was the unanimous part of it, but I think the problematic aspect of that case, and I think it seems kind of, I don't know, in some ways self-evident that, you can't have states, kind of interfering with a federal election in that kind of way, especially for the office of president. But then the court went on to conclude that in addition, the states could not limit ballot access for congressional offices, which was not an issue in the case. And then the court went on to say, the majority, to say that the only enforcement mechanism under Section 5 of Section 3 of the 14th Amendment, which this Trump v. United States was about, is for Congress to exercise its regulatory powers under Section 5. And I just want to remind everyone that a couple terms ago, the court said under the Voting Rights Act that even though Congress had exercised its power to regulate, elections under the voting, by reenacting the Voting Rights Act, that was not good enough, right? That, it had made some mistakes in doing that. So it's very, this sets up some uncertainties. First of all, they decided these issues that were not presented in the case without any, argument or discussion about them. And then second, we have this uncertainty lurking out there about exactly what does Congress have to do to exercise its enforcement powers.
Yeah, and I think what you're already hinting at, and why I at least wanted to touch on that case, even though it seems so long ago, and I think we probably all agree, and at least the justices all kind of agreed on the outcome of that case, was exactly what you said at the end there. And Justice Sotomayor, in what was labeled a concurrence, but it seems like originally was meant as a dissent, says, quote, "Yet the court continues on to resolve questions not before us." And that might be a theme that we see throughout some of these cases. But let's jump into the kind of the major Trump case of this term, which was released on the very last day of the term, which was in July, which was fairly late for the court to release these opinions. And kind of the headline of that, and it's a 6-3 split written by Justice Roberts, in which the court holds that under the constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. And he is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. So this is one of those ideological splits. In some ways, perhaps not surprising, with given Justice Roberts in particular, his view of presidential power, and something that we had known that that Justice Thomas has had an expansive view of presidential power going back to like the cases under the Bush administration or even the Clinton and Obama administrations. So it wasn't, maybe the result wasn't completely surprising, but perhaps how far the court went was maybe a little surprising. So I'm curious, Professor Landers, when the decision came out, as you were reading through it, what were your thoughts?
Yeah, I mean, I think so. First of all, I think it was an expansive decision, as you say. I think the second aspect of it is that it doesn't actually, again, provide any guidance for the courts about how to administer these rules that the court has set up about presidential immunity. I think Justice Barrett's opinion actually does a better job of doing that. Steve Vladeck, who has his one first, what is it? It's a blog, I guess. I don't know how you characterize what he does every week, but he points out that her opinion, because it took a much more limited view of the insulation that the president should receive from suits, she didn't really want to call it immunity. And she wanted to say that the lower federal courts, that the Constitution kind of sets up this presumption, and the lower federal courts should have to make some determinations about, whether it's an official act that he's engaged in, and whether, how it fits into, these historical characterizations of exercises of presidential power that are kind of at the edges of the president's power. And then that the president, who would be subject to criminal prosecution in such a scenario, could then seek interlocutory review of that determination. And so that, I think, I don't know if the dissenters would have agreed with her on that if that were the court's opinion, but that was a kind of middle road. And then finally, the court decided a fourth thing in that case, which was that evidence developed through examination of the president's official acts or his presumptive, his exercise of presumptive authority could not be used in prosecutions for his unofficial acts. So, I mean, this is nowhere in the Constitution. I mean, this isn't the first time the court has just kind of made up some kind of rule like this, but that's really kind of astonishing. And I think the origins of it, for the lawyers who are following all these things, is in the Trump v. Hawaii case, which was the case about, banning travel from Muslim countries, where the court said, oh, well, we can't look at these things the president said during his campaign for president about his motives for doing this thing, which would be unconstitutional and bad motives. We can only look at what the government is saying now. And that just seems to be a completely, putting on the blinders approach to looking at what the government is doing in particular situations.
In the practical effect of that final thing that you brought up is that President Trump was supposed to be sentenced on his felony convictions in New York last week. But I think Judge Merchan correctly gave time for both sides to brief this issue, because a lot of the evidence used against President Trump at that trial was evidence that was based on actions that he did when he was in office. And to your point, the court, through the majority, essentially says that you're not allowed to do that. So that will be interesting to see how that plays out come September.
Right.
We talked, Brendan introduced your experience in judicial ethics, and one of the things that came up a lot for me as I was reading about this during, or I guess prior to the rulings being made public, is whether or not Justice Alito and maybe even Thomas were sort of rightfully adjudicating this, that maybe they should have accused themselves. Where do you fall on that side, or on that question?
Yeah, so I think that's a tricky one for a couple of reasons. I generally think that that the two of them are in kind of different positions with respect to that conflict of interest issue. And so I think Justice Thomas, with, actually, maybe they're not so different, now that I'm thinking out loud about this, but I think so. First of all, there's this issue, they're both saying that their spouses are responsible for some of the problematic conduct. And so, you don't always want to be, taking action against people for the conduct of their spouses. But, one thing is pretty clear about judicial ethics, that the people in the household, right, are people who can put the judge in a conflict of interest situation. And so I think that's, certainly, arguably true in both of these circumstances, with Ginny Thomas's actions about, trying to, encourage challenges to the outcome of the last election. I'm trying to word that, non-problematically. And then, this flying of the flags, which I think is definitely, at the home, which I think is definitely kind of over the line. So I think any judge who really was concerned about the reputation of the court, or the reputation of the court for the integrity of its decisions, might have looked at those situations and said, maybe I ought not to participate, that whatever the court decides will play a lot better with the public if I'm not part of this vote. So I think that this goes to this larger issue that the court has refused to adopt a binding code of ethics that they will even enforce against each other, let alone having some external authority enforce it against them. And second, they resist the notion that Congress can make rules about this aspect of their work. And I think that just has to be wrong under the Constitution. The Congress would not be telling them how to decide cases, which is the core judicial function, just saying if you're going to decide them, you have to adhere to conflict of interest and other kinds of rules that every other judge in the country has to adhere to. So I think that has been a building and continuing problem for the reputation of the court.
Absolutely. And we talked about that back in October. And I asked you at that point, like, why wouldn't they do this just for like the reputation of the court? And you had a good answer about that. Subsequently, in November, they did come out with these guidelines of judicial ethics. But I think, as Ricky points out, this almost like made a mockery of that, because it made it clear just how toothless that code of ethics actually was, because we had what you would think were prime examples of justices who should have recused themselves based on these ethics that they agreed to, that we're not then doing that.
Right. And so, and just for, an example, the Massachusetts Supreme Judicial Court, I'm trying to remember what the timing of this was, whether it was before we talked the last time or it's happened since then, took disciplinary action against a judge who had a Facebook page, which had, recited all kinds of political opinions and things like this, and said, this is just completely out of bounds behavior for a judge, or a member, of the judge's household. So, yeah, I think it's a problem.
Sure. All right. So I want to stick with this opinion for at least a few more minutes, because Justice Sotomayor, who has become kind of famous for her acerbic dissents over the course of this term, she writes at one point in her dissent, quote, "The President of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he will now be insulated from criminal prosecution. Orders the Navy SEAL Team 6 to assassinate a political rival, immune. Organize a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, 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 immune." And later, she closes by writing, "With fear for our democracy, I dissent." So that got a lot of play, I think, on headlines or social media, people kind of pulling that out and quoting that. And what Roberts does in the majority says, the dissent, quote, "strikes a tone of chilling doom that is wholly disproportionate to what the court actually does today." And I think that's kind of what the two sides that you have there is the dissents in this case and other cases saying, like, this is really a disaster, like a disaster of a decision here that strikes a blow to our judicial system, potentially our democracy, and the majority saying, like, they are really wildly exaggerating and kind of using fear mongering to strike out what's actually a legitimate legal decision.
Well, what I think about that is that I think, because the history is on the side, I think, of Justice Sotomayor's argument. I mean, we have not had a history, right, for of repeated nuisance, crazy lawsuits against the president for official decisions, and only when we had a president who was arguably participating in events connected somehow to what happened at the Capitol on January 6, 2017. Did we have this, result in, a criminal action against the president for some of the actions taken? We also had this president, who, took documents, classified documents. This is the case in Florida, right, which was just dismissed today as we're recording this podcast. And after many opportunities, being given many opportunities just to return them, refused to do so. And, other people, as has been pointed out, President Biden, others have, walked off with some classified documents. But when it's been pointed out to them, they all readily returned them. So I'm not trying to build the criminal case here. I'm just saying that this president has taken these like extraordinary actions. And it's really the first time, right, that the criminal powers of the federal government have been used. And I think it's because we have extraordinary situations. And, to make a rule that would bar that sort of thing, when for the entire previous recorded history of the country, this was not a problem, seems to be a little bit preemptive.
Given kind of this broad view of presidential immunity, is the only kind of recourse or only way to hold presidents accountable going forward through the impeachment process?
Yes, and the electoral process, voting people out of office is always an option, right? And I think,
Unless they're allowed to election tamper and change the fact, right?
Yeah, no, interesting. Does election tampering, is a president going to be immune from that kind of thing too? Well, we'll soon find out, right? Because we've got that Georgia case going on, right? So I think it's very I think that is, the limitations are really, and the constraints on criminal prosecution are quite significant. And I'm not enough of a criminal lawyer to really have an opinion about, how significant they are.
Just to wrap up, or kind of close the loop on that particular case, is Professor Landers just mentioned that this morning the classified documents case against President Trump in Florida was thrown out, and that seems, and we'll have to find out more about this, but seems to come directly from Justice Thomas' concurring opinions in this case, which essentially argued that special counsels wasn't legally appointed and couldn't actually prosecute a case against the president because they did not have the authority to do so.
Right. So, one option might be for the attorney general just to assign the case to, somebody in a United States attorney's office somewhere, or, experienced but line prosecutor at a main justice, and see if, and to pursue the case that way, because double jeopardy is not attached yet. So, the case could go forward.
The reason why they didn't do that is because you didn't want to have the appearance of the Democratic president's Justice Department prosecuting a Republican presidential candidate, which you kind of understand from a political level. But as Professor Landers points out, that case is not dead yet. But I just think that there are some pretty far-reaching implications for this case. Right. Speaking of far-reaching implications for a case, we talked about this back in October. Sorry, I think I paused there for a minute. So we talked about this back in October when we had you on, Professor Landers, and this is why I was particularly excited to have you on for this term, is that the major decisions and the decisions that are likely to have the biggest impact on the most amount of people in the United States coming out of this term are these administrative law decisions. There was a series of them. I want to start with the Chevron Doctrine cases, which for lawyers out there were kind of two paired cases: Loper Bright Enterprises versus Raimondo, and Relentless Inc. versus the Department of Congress. Professor, feel free to kind of expand on what I'm going to give as like a general overview of what these cases were about. But essentially, the Chevron Doctrine was a case which wasn't even supposed to be a major case. It really wasn't at the time in I think 1985, at least in the 80s, which was a conservative victory at the time. It allowed President Reagan's EPA kind of interpretations of like these clean air, like easing clean air acts, rules or regulations, and essentially said, when Congress passes a law that is ambiguous or doesn't fully lay out every procedural step that the executive branch has to take to implement the law, we are going to defer to the agency's interpretations of that ambiguity. That held for 40 years. I think it's one of the most cited cases in federal law. I think over 18,000 times. This court has backed away from it in recent years, hasn't, I don't think, cited it in the last 8 years, and certainly now that it has a supermajority that has a judicial bent against the quote-unquote administrative state, rolled back the Chevron Doctrine. And essentially what that means, like practically, is no longer are courts going to defer to agencies' interpretations of ambiguity. courts are going to have the discretion to decide what the law actually means themselves. So first lenders, like, why is this such a big deal?
Well, I would say it's a big deal for two reasons. Because once again, the court has jettisoned a longstanding precedent. And yes, it's true that the court itself had not been terribly reliant on the Chevron Doctrine in recent years. The lower federal courts actually did find it to be a very useful doctrine, I think. So that's point number one. Point number two is that I think that what I see it as a big power grab by the court. I think because we've now shifted, right, the control of some of these interpretive questions from the federal agencies, who in theory have some expertise and who in theory are controlled by that all-powerful president that they like to refer to, and shifted that control from one of the political branches to the judiciary, who are really, and particularly the Supreme Court in this context, accountable to no one. And so I think that, other than, the court of public opinion. So I think that that is, pretty arrogant and pretty irresponsible. And I think that, the much was made. I don't know if we're going to talk about the Ohio against EPA case, but that case is also quite significant. And in that case, the court repeatedly, in the first draft of the opinion that was publicly released, referred to the wrong nitrogen oxygen substance in talking about this Clean Air Act regulation. So people are sort of saying, well, you purport to know and to be able to tell the EPA what to do about these things, but you can't even tell us what the right substance is. Now, I'll, cut them some slack and say maybe that was in the nature of a typographical error or something like that. But I think it's very problematic. It's a power grab by the court.
All right, so how do you respond to Justice Gorsuch's argument in his concurrence, which was lengthy? It was one of the lengthiest opinions, I think, released the entire term, this concurrence. And what he says in it is that all this decision does is return the role of the federal courts to the role that it had for 170 years before Chevron came along, which is when there are cases and controversies and questions about what a law means, it's the job of the courts to decide what it is. And all we're really doing is just giving the power back to the courts that we erroneously gave away 40 years ago.
Well, so I would say two things about that. I think that it's not really, I think this sort of rule of judicial preeminence or predominance in statutory interpretation, was established in Marbury versus Madison. Everybody knows this, but but that was well before there was an extensive, technological administrative state that had to be conversant in a lot of areas with which the judiciary and lawyers, the general run-of-the-mill lawyer, are not conversant. So I'm not sure that this is another one, go back in time and we'll have that. I'm just not sure that that's one of those, that's a very persuasive argument. I also think that that it wasn't just like a free pass for the agencies, right? It was first of all, the statute that the agency was operating under, that the agency was interpreting, had to be ambiguous. And so, and there are some statutes that actually have a fair amount of clarity. And then second, that the agency's interpretation had to be reasonable. So an unreasonable interpretation, or an interpretation that was inconsistent with the law, was not going to be upheld even under the Chevron Doctrine. So I think he's kind of overstating the impact of the Chevron Doctrine on what courts do, and understating the impact. A reporter asked me a really interesting question about all of this the other day, which was, are the federal courts going to be up to this new expansive role that the court has now, placed them in? And I'm not sure I know what the answer to that is. I guess we shall see, but I think it's certainly going to take them maybe a lot more time, and maybe get some of them in over their heads and try to figure out, some of these, interpretations that agencies promulgate and very complicated rules. I don't know. We shall see what the impact is on the lower federal courts.
And one more thing on these cases, because I think not only do these decisions have a big impact on federal courts, but some of these other ones that we're going to talk about are going to have this big impact on it.
I'm listening. Go ahead.
But there's been a general backlash against the administrative state in general, both from like a policy perspective and from a judicial perspective. And that argument is that the separation of powers, what's happened in the last 40 years has greatly expanded the unelected administrative state at the expense of both Congress and the judiciary. So what we're doing here is actually we're just correcting what was for 40 years, a generation, an overreach of the power of the administrative state. So what about, do you have a response to like an argument like that?
Yeah, I mean, I actually do. I mean, I call on people to remember what it was like when Franklin Roosevelt took office in the depths of the Depression, and the Congress was desperately trying to pass laws, right, to try to address that problem. And the Supreme Court saying, no, you can't do that. No, you can't do that. People are suffering, but you can't do that. And I just think that that's perhaps where we might be headed back to. It's probably a good segue to the gun conversation, maybe, I don't know. But I just find that argument to overstate too much, right? And that the idea that Congress in a complicated world like we're in now is going to be able to pass, a statute regulating, what kinds of chemicals, upwind states can put into the air that will affect the air quality in downwind states is just an unreasonable view of how the world is working now. I challenge people to ask, what kind of occupational safety regulations, they don't want workers to have, right? We have, in the Northeast now, we're experiencing this tremendous heat wave, right? Do we really want agricultural workers and construction workers who have to work outside in these conditions not to have required breaks, not to have water, have adequate hydration during these times? I mean, I think it's a really cruel society which would say that the government cannot require employers to provide those kinds of accommodations for workers in the workplace. So I think it's, I just don't understand how the world as we know it could function in an era without the ability of agencies to take some of these actions. I was trying to find just, so I actually think that maybe the overturning of Chevron is kind of the least of our problems with what the court has done this term. Maybe not the least, but it's not as much of a problem because, the backstop for Chevron has always been this older case from the 1940s called Skidmore against Swift, which is a Fair Labor Standards Act case. And the court there should, really consider this issue of how much effect should courts give to the statutory interpretive decisions of agencies. And the court said in that case, the weight of such a judgment will depend on the thoroughness evident in its consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all those factors which give it the power to persuade if lacking power to control. And I think that, that maybe we're back in the Skidmore realm now after the, rejection of the Chevron approach. And that approach seems okay to me because I just don't think that it would be defensible for the court to say that the agency's view of how the statute should be interpreted, it should be irrelevant.
I know we don't do a video podcast. I just want to point out how cool it was, how quickly you found that out of a book. The I think maybe I just wanted to tack on that Gorsuch's sort of implication that this is somehow takes these questions out of the hands of unelected bureaucrats, whereas, the head of the EPA is a political appointee. All of these people turn over and when elections turn over, and instead the questions are going to be answered by by judicial appointees who have in some cases, lifetime appointments and are not accountable at all to the electorate. So, and of course, the administrative burden of working through the legal process is probably just as bad as it is working through sort of the government bureaucracy. So I guess I don't necessarily buy that argument from that standpoint either.
Yeah, and I would say that the United States is an outlier among Western democracies, and the extent to which people turn over when an administration changes. I mean, we have something like, I don't know, somewhere between 3,500 and 4,000 people who turn over each one. I'm not sure exactly where that number rests. And in other countries, it's a much lower number. That, there's this assumption that in order to keep things working, right, you need this core of steady civil servants who will keep the government functioning, regardless of what the political philosophy is of people who are in charge, who may shift the direction, right? And, we kind of see that happening, in the UK now, our friends in the UK and our friends in France, right, are going through, some of these changes right now as well. But it's, a change in the sort of direction at the top, and not, what's happening on the day-to-day basis in all the agencies.
Well, I think that's quite honestly the Trump argument in his supporters is exactly that, of like, we can't make our changes because we have all these people that are just embedded there impeding our progress. And we'll see. He certainly has plans if he is reelected to maybe alter that even more so than it currently is. But speaking of a potential increase on the burden of the federal judiciary, there was another case, Professor Landers, the Corner Post case that again, we'll try to briefly go over. This is Corner Post versus Board of Governors. And in it, the court overturns what was previously a default 6-year statute of limitations applicable to suits against the United States. So if there was an administrative law pretty much said that you had 6 years to challenge it, otherwise you couldn't challenge it because it was beyond the statute of limitations, it was too late. And the purpose of that is to prevent just excessive litigation that could go on, that could be challenging laws 10, 15, 20 years down the road. That was overturned, which will allow businesses to bring these suits whenever they really are harmed. So, Professor Landers, do you want to talk about how that might impact?
So just from a technical point of view, I mean, the court didn't really overturn the statute. There's this statute in the judicial code that says that every civil action commenced against the United States shall be barred unless the complaint is filed within 6 years after the right of action first accrues. So I think, technically speaking, Corner Post was interpreting that language, when does the right of action first accrue? And the court said, anyway, I mean, I had to look this up myself. So anyway, because it's like, what are they talking about? So the court is saying that the action first accrues whenever a particular individual, company, whatever regulated entity is first injured or, suffers harm as a result of the regulatory policy. So it's sort of like importing this, tort. This is for the lawyers in the audience, this discovery rule in torts, right, to this administrative litigation. So the first point I will make about this, if we had a Congress that was so inclined to kind of fix these things, Congress could pass a statute that says when a right of action first accrues is when 6 years, within 6 years of the agency taking the final action. It's not this other thing. So, then there might be, a party might say, well, there's a due process argument there, but I think that would be a much harder argument to make. So that's number one, that Congress can change this. This is not a constitutional decision. Second, I think this one is actually even more significant than the Chevron decision, than the Relentless and Loper Bright decisions, because it really does destabilize in every way any final agency action, because it could be challenged at any time in the future. And so I actually don't think most regulated entities want that, even if they don't like a particular rule. What you'd like to just know what the rule is. That's actually the most important thing. And if the rule is one way that today, and then the next day some party is able to challenge it and it's no longer exists, I think it's very problematic. And I think I don't know. I think this is a very destabilizing one, and it raises the prospect that there are a lot of organizations who professionally think about ways to challenge all of these things, right? And so they'll say, I'm going to start a company like that web designer in the 303. What is the name of that case? I can't think of the full name of that case. And say, I'm not doing it now, but I'm planning to do it. And this rule might be really bad for me. That's been in effect for a long time. So I just think that this is very, very challenging. And I think, and if you think about it in relation to things like what the FDA does and the decisions the FDA makes, drug and device manufacturers, they invest billions of dollars in research to bring a product to market and to get FDA approval, and to be constantly subject to the threat that someone could challenge that action at any time is very destabilizing.
Yeah, Justice Jackson says as much in her dissent, which was fairly fiery as well. It says, taken with the ruling, the Loper Bright and Relentless cases, the Chevron ruling, she says it could create, quote, a tsunami of lawsuits with the potential to devastate the functioning of the federal government. And just kind of to wrap up these administrative law cases, the third major one, in my opinion, was the SEC, the Securities and Exchange Commission versus Jarchese. Again, we talked about this briefly, or we talked about this in October, if you want to go back and listen to that kind of overview of it. But in brief, the SEC had like a routine practice of imposing fines in enforcing like its in its administrative proceedings. And so like what the SEC does, it tries to prevent fraud or like penalize security fraud, really. And in doing that, it would often impose fines. And this court, 6-3, found that violated the Seventh Amendment's right to trial by jury in all suits at common law. And I guess like this was one of those. It's a 6-3, but there are the six judges all they signed on to Justice Roberts's opinion, every word. And so to me, and I think as reading some of the articles about it, like this is not something that's going to be easily overturned. It's not a 5-4 decision. It's not 6-3 with 3 different concurrences. This was 6 judges firmly agreeing that what the SEC does, and this isn't just applicable to the SEC. You could bring in the FDA, EPA, CFPB, like they all kind of function in the same way. And the court is saying like, they no longer can function in that way.
Well, and it's not clear. They said in certain kinds of cases, to which the Seventh Amendment would have applied in 1791, whenever it was that the Seventh Amendment was ratified, right? That cases of common law, there's right to civil jury trial and the agency adjudication process, before an independent administrative law judge, in theory, but that's under challenge as well, is not sufficient to meet that Seventh Amendment requirement. So this instead of having it's going to have a tremendous effect on agencies, because it's just going to make the calculation different about whether to bring an enforcement action against an alleged violator of the securities laws. Mostly they're like disclosure violations or fraud, allegations of fraud. But it is also going to make for a tsunami of work for the federal courts. And back in the day when I worked in the Department of Justice in the Clinton administration, it was in the late 1990s. And in mid 1990s, I should say, the Congress had passed the Crime Act of 1994, which created all these federal crimes, for going to another state to avoid your child support obligations. So there was the Child Support Enforcement Act. There was the Violence Against Women Act, right? Taking someone across state lines, going across state lines to commit violence, gender-based violence. And it actually worked both ways, even though the statute is called Violence Against Women Act. And, it's several other, crimes that arguably could be prosecuted by state prosecutors under state criminal law. And the federal judges, first of all, they misperceived, the quantity of litigation that would come as a result, because there had to be this interstate component to it. It wasn't just like every child support action could be brought in federal court. So once they understood that, then they felt better about it. But when they thought that all of those cases were going to come to the federal courts, the federal judges were not happy about it, because it was just going to be, first of all, they had not signed up to do that kind of case. And second, it was just going to be this, huge volume of cases that they weren't used to experiencing. And I think that that is one possible outcome of this decision, if it's not limited in some way. And as you pointed out, it's not just the adjudication process at the SEC that's, in effect. Almost every enforcement agency has some capacity to do have an internal adjudication process. And now we have this question again. This is this uncertainty feature of what the court has done this year. We don't know exactly which enforcement actions are going to be in the Seventh Amendment box and which ones are going to be it's okay for the agency to pursue. We don't know what the criteria are going to be.
Will certainly be exciting to find out over the next few years, I'm sure. But that segment was for my administrative law kind of nerds. But we're going to move on just a couple other kind of realms of decisions here fairly quickly. The first is, we talked about this, that we had seen these coming down the pike, is the abortion cases. So we had mentioned this at the very end of our conversation in October, where there was a judge in Texas had essentially said that the FDA couldn't expand access to the abortion pill mifepristone. And we knew that the Supreme Court was going to have to take it up. They did take it up. And what they did was they sent it back saying that the people who had challenged the expanded access to mifepristone didn't have the legal right to sue, which is known as standing, because they weren't actually suffering any particular like concrete or actualized harm from their moral or political objections to the mifepristone. And so I guess policy-wise, like practicality-wise, what it does, it allows people who are currently have access to mifepristone to maintain that access, but it doesn't necessarily, it didn't reach the merits. It didn't say what the FDA did was okay. And so essentially what it leaves open is further challenges down the road.
Yes, I would say that. And the other thing, the court has taken, different views of the standing doctrine, who has a right to sue question over time. And the court has, the ideologically conservative justices, generally speaking, have wanted to restrict standing and the opportunity to sue because they think it's going to be people like environmental groups or civil rights organizations. And then, liberal justices in general, having a more expansive view of standing. Well, people who were affected by decisions ought to be able to challenge them. And this case was unifying on the theme that actually the organization, what was called the Alliance for Hippocratic Medicine, actually didn't really meet any of the traditional criteria for standing. Now, the problem with that is that there's been this issue lurking out in all of the abortion cases about who has standing to bring a challenge to a particular abortion restriction. And you know, this gets a little bit technical, but the exception to you having to be personally harmed has been this third party standing doctrine, that someone who's in a close relationship to you, who could, you know, argue the case as forcefully as you can, say a woman who needs an abortion, who wants an abortion, and when the person who is actually harmed is not in a position to be able to bring the challenge, then that the court will grant standing in those situations. So if you look at all the abortion cases, it's always Planned Parenthood, a Planned Parenthood organization somewhere, some other kind of women's reproductive health care clinic, where the courts have said that the clinics can, and the physicians at the clinics can bring challenges to abortion restrictions. So with this more restricted, with this, you know, decision in this case involving mifepristone, Justice Thomas wrote a sentence that I will read. So just as abortionists lack standing to assert the rights of their clients, doctors who oppose abortion cannot vicariously assert the rights of their patients. So first of all, notice the language, right? There are the abortionists who have clients, and then there are doctors who have patients, right? Because there has been this mythology in the anti-abortion movement that doctors, these evil abortion promoting doctors, are the ones who are forcing women against their will and against their best interests to have abortions. And this framing of that standing question just feeds totally into that. And it really is destabilizing and you know, really disenfranchises women, right? That women, people seeking abortions, you know, the reason they go to ask these questions is because they understand that they are pregnant, and they understand that what the consequences are. And, you know, and that most doctors, and I would say almost all people who perform abortions, it's really the choice of the patient. If the patient decides they would like to carry the pregnancy to term with the appropriate medical assistance, that's fine too. It's the patient's choice. So anyway, I see this as kind of a threatening cloud on the horizon for any ability to challenge other abortion restrictions.
What is that saying, like the canary in the coal mine? With like Justice Thomas has frequently done this, right? This is, on the surface, it's a per curiam, like by the court 9-0 decision, sending it back. We all agree on it, but Justice Thomas, throughout his entire time on the court, has written his own, whether concurrences or dissents, and he puts something out there. And for a long time, people said, well, we don't have to worry about that because he's out there on an island. But increasingly, he's not on an island as much anymore.
Right. I mean, so, you know, in that case, you know, no one else signed, none of the other justices signed on to his opinion. But, you know, that, you know, I'm not confident about what will happen in the future with regard to that. And as you say, it was not a decision on the merits. So if they find another challenger, if the anti-abortion movement is able to find another challenger who might have to have standing, it's hard for me to imagine what that would be, given what the court said about these particular plaintiffs in this case. Then, you know, the challenge could come again.
Absolutely. And speaking of another abortion decision that wasn't decided on the merits, there was another one, kind of two cases, both out of Idaho. And Idaho, in the wake of Dobbs, passed a law, an abortion ban, essentially, which carves out exceptions only to save the life of the mother or in cases of rape or incest. But a federal judge says that conflicts with the federal law, which is called the Emergency Medical Treatment and Labor Act, which is a 1986 law that requires emergency rooms and hospitals that receive Medicare to provide necessary stabilizing treatment to patients who arrive with an emergency medical decision. And again, the court sent it back and essentially said there's more that has to be done on the trial level to get up there, which, again, practically it preserves women's right who go to hospitals or clinics in Idaho if they are suffering from an emergency medical procedure to get the treatment that they need. But what it also does, kind of very much like the McPherson ruling, it just kind of delays it holds these policies kind of in limbo right now. And I thought what was interesting was that 5 judges, Chief Justice Roberts and Sotomayor, Kagan, Kavanaugh, and Barrett, all agreed we have to go back, send it back. And then 4 judges wanted to decide it on the merits: Thomas, Alito, and Gorsuch, who I think likely would have come out that the Idaho law does not violate does not conflict with the federal law. And Justice Jackson also wanted to decide it likely in the other way. So again, this is a case which doesn't necessarily affect anyone's rights right now, but I think potentially had some clues about what might be coming.
Yeah, so the first thing that happened, so this case, the court actually dismissed the petition as having been improvidently granted, right? Because it was granted without any significant factual development. And I think it's actually interesting to listen to the oral argument in the case, because you see several of the justices having these aha moments when the litigators are asked questions, and sometimes they don't know the answer to the question about the impact of the Idaho law. And sometimes, even on the federal government side, the government, made this, a representation that EMTALA has never required, a hospital to provide an abortion just because a woman was a pregnant person was suffering from an acute mental health episode in the emergency room, right? So because the standard, complaint about abortion laws is that, well, it's just, somebody can make up some, phony mental health issue and get an abortion as a result of that. And that actually was, is actually not the case necessarily under EMTALA. So, anyway, it was dismissed as improvidently granted. The Linda Greenhouse wrote a really great piece about, what kinds of, how, the court got itself into this bind of having to admit that it was wrong to have taken the case. The other situation, the other issue is that, I think for at least until the case is litigated at trial, that it will be possible for women. And the problem with the Idaho statute was that the only exceptions, other than for rape or incest, for victims of rape or incest, were for women who were, whose lives were threatened by continuing the pregnancy. There was no exception for grave health consequences, like, permanently interfering with, a person's fertility, or, significant kidney failure, which, ultimately could set you down the path to having to have a kidney transplant, all of these severe consequences. And so what hospitals in Idaho were doing while the federal government was enjoined from enforcing the EMTALA statute was airlifting women to states where they could get the procedures to protect their health. And one of the leading emergency hospitals in the state of Idaho reported that in the entire year prior to the enactment of this Idaho statute, they had airlifted one person who needed very specialized care under those circumstances, and that while the federal statute was enjoined, they were airlifting, patients like one every week or week and a half to other states. So it was really quite a significant impact on their practice. The other, I think it doesn't, and I think that what it does show is that there are a lot of uncertainties to be worked out here in these situations. I mean, I don't think it's good enough. I mean, I think that what states like Idaho say, oh, physicians are being too cautious. Of course, if it's medically appropriate, we won't criminally prosecute them. Well, you're a physician who spent, upwards of $200,000 on your education. And you're going to be second guessed by a prosecutor who gets somebody to say that you didn't really have to perform that procedure when in the moment it seemed like it was the right thing to do. So I just think that that's not a very satisfactory answer on the part of states trying to enforce these abortion bans, and they have to be a lot clearer about it if they're going to do it. I prefer that they not do it, but if they're going to be doing it, then they need to have some really pretty clear standards so that the physicians know what they're doing. The other issue that this raised is that so, Brendan, you may remember this from first year con law, right? The typical framing of a spending clause problem, right, under the federal statute. This here we have the Medicare program, which is, giving money, and the Medicaid program giving money to states, but the Medicare program is giving money to private organizations, not necessarily governments, to provide healthcare services to citizens, right? And so the question is, that is, discussed in some of the court's opinions in sending the case back, can a spending clause requirement attached to money going to private entities operate to insulate those private entities from prosecution under a state criminal law? And so that maybe is another interesting constitutional question that might arise out of this case.
If I was a student, if I was an incoming student to Suffolk, I might flag that one for a potential constitutional law exam in 5 months.
Right. So see, you were astute. You took these hints, right? Dropped in class about the current issues. And some students don't really believe me. I'm not really good at writing fiction, right? So I'm just, looking around at what's happening in the world and putting those kinds of questions on the exam.
Well, Ricky, for a little bit of context on this, like where the constitutional law is a monster topic, right? So when you're studying for exam, there's almost like infinite amount of things that a professor could ask about it. But I remember with my study group, and I had like 6 topics. I was like, I think we're gonna get 5 questions, or I think it was 4 questions for Slanders. I was like, they're coming from these 6 topics, given what we've talked about in class and what's happening in the world here.
And were you right?
I was like every single one. They were still brutally difficult questions, but like I at least knew the topics. Yeah.
Right.
That's right. The last thing I want to talk about is the major gun case. We've had a major kind of gun laws or gun decisions by this court, most especially New York versus Bruin. And since that 2022 decision, lower federal courts have struggled to implement or decide what it means for laws to have what does it mean for like the history and tradition, like how closely does the current law have to mirror like a previous analog of when the Second Amendment was passed. And so in this case, what you had was I think it was in Texas, where a man had abused and battered his girlfriend, and as part of, she went out and got a protective order against him. Part of the protective order specifically said that he was not allowed to own a gun because as part of his assault of her, he used a gun. He also fired that gun at a bystander who witnessed the incident. And then post Bruin, he came out and challenged that and said this was a violation of my Second Amendment right to bear arms. And this case was closely watched for a couple of reasons. One, because the court didn't give lower courts a ton of guidance in Bruin of how to interpret this new test that they had. So courts are kind of been all over the map in what actually qualifies as a good law versus one that's infringing on people's rights. And then there was also the question of like, how far is this court really going to expand Second Amendment rights? You lose me? And so I think to potentially a lot of people's relief, we have an 8-1 decision saying that written by Chief Justice Roberts again, and which says that this was a good law because there are historical analogs for removing firearms from people that the state has deemed actually dangerous. You have concurring opinions from Joseph Sotomayor and Justice Jackson, which both say like, hey, yeah, I agree with this, but I still think Bruin was wrongly decided. And then you have a dissenting opinion from Justice Thomas saying that we shouldn't be taking guns away or states shouldn't be taking guns away even in these situations. So Professor Landers, thoughts on this case?
Right. So, I mean, I guess relief is the right word because, the court, or at least the majority, didn't kind of double down on, well, domestic violence was okay at the time of the Constitution, unless it was really extreme, and he didn't kill her yet. So, he gets to continue to have his gun. So I think a couple of things. So the court did somewhat clarify the historical test that the courts are supposed to use in these cases. I mean, the court said that 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 the law has to be relevantly similar to law, similar to law, like laws that are relevantly similar, that were good historical analogs. He said that it had to be an analog, not an exact twin of the statute. And the majority opinion does seem to chastise the lower federal courts for getting it wrong. And I think, some of the, Sotomayor and Jackson are like, hey, it was our fault because we didn't actually provide a lot of clarity. So let's not beat them up because they got it wrong. And so the court finds, two, categories of laws that, took steps to disarm people who were thought to be problematic or to put other people's safety at risk in, the times of the Constitution. Another feature of this, I mean, if you were to read the facts about, Mr. Rahimi, who was the one who challenged this law, this is like, you have to be careful who your plaintiff is sometime, because he wasn't actually a poster child for responsible use of firearms. And so that was maybe another contributing factor to the outcome of this case. But I think that Justice Thomas is, kind of doubling down. He takes this view that, the Second Amendment literally means what it says, even though we don't really say that about any other provision of the Constitution. We don't say that about the First Amendment. We don't say, about other important parts of the Constitution. And therefore, you really cannot take these preemptive actions to prevent people from having guns. And the only thing you can do is to prosecute them, make rules that then penalize them if they do the bad thing with the weapon. And I would say that one of the, I don't know, this is going back to our comments about the administrative state. One of the important features of the administrative state is trying to take preventive action so that to prevent harm to people, prevent harm from drinking, unsafe water, breathing unclean air, working in a workplace that is demonstrably dangerous without adequate protections. And here, we have a justice of the Supreme Court arguing, no, that we really as a society cannot do that. The most we can do is tell people, you'll have to pay money or you'll have to go to jail if you violate the law, but otherwise we cannot take your gun in advance of you doing the bad thing. And I find that very, very troubling. I find it, particularly troubling after the events of yesterday when, there was a shooter with an automatic weapon who, was, aiming at President Trump and, killed one other person and two other people are seriously injured. I don't know what their medical condition is today, but I find it, and this is a person who is about as well protected as anyone, in the society. And, the Supreme Court justices are pretty well protected too. And so it just seems to me that the government ought to be able to take some action to prevent these kinds of things from happening.
Fair enough. All right, we've been in the weeds with some of these major cases, and I think I found them very interesting and illuminating. Hopefully people listening out there did as well. But first, I just want to give you, a few minutes. You've been exceedingly generous with your time already. But if we have all these different cases, we have presidential immunity and administrative law and guns and abortion. But are you able, and I know it's only been a couple of weeks since the close of the term, but have you been able to identify potentially any themes or threads running through this term or of the court or of this court in general?
I think I think the word I would use is uncertainty, that the court's decisions are creating. Announcing some big, broad principles, but not providing a lot of details that give guidance on how, these principles will be implemented, particularly in the administrative law area, the case about administrative adjudication, how are federal courts going to deal with the Chevron free zone that the court has now created? Really what is going to happen with the abandonment of with the change in the interpretation, it's not the abandonment, the change in the interpretation of the 6-year statute of limitations on challenging agency actions. So I think one possible response is that agencies just may stop trying to do things. And, for some people that might be, I think, the desired outcome. But I think that it will also leave a lot of problems unaddressed. So I think uncertainty. I think we also have a lot of uncertainty about this interplay between some federal laws and state laws in the abortion context. And I think there's a lot more complexity that's going to evolve there, as states try to become more aggressive in enforcing criminal bans or objecting to, federal laws that or trying to enforce federal laws that would seem to, prevent the shipment of, abortion drugs or surgical instruments used in abortion procedures across state lines. I'm referring now to this Comstock Act, this 1874 statute that was this moral statute, and that now, people are trying to revive. So I just think there's a lot of uncertainty out there. And there was, regardless of, what your views were, there were at least some degrees of certainty within a reasonable range about how agencies could operate, what the rules were about states regulating abortions. There was some space for gun regulation. And now, where it's back to square one, trying to figure out what's appropriate and what's not.
An interesting and challenging time to be a constitutional law professor or student or a lawyer dealing with any of these things.
It really is. People ask you, so what is the answer about these interstate criminal prosecutions? Well, no one really knows, right? Because we've never really quite dealt with this before. So we just are now, everybody's just working on their arguments.
Yeah, and again, we'll get ready for the October 2024 term, which I'm sure will be upon us in short order, and we'll probably continue to flesh out some of these issues. But Professor Landers, again, you've been more than generous with your time across both these episodes. Thank you. I really don't think that we could have had someone better to discuss whether it's admin law issues or health law issues. Like, you're truly an expert, and so I appreciate you illuminating some of these really complicated issues for us. Thank you.
Well, thank you for having me. I really appreciate it and enjoy the conversation. So.
Yeah, and as I said back in the fall, it's just such a treat for me, and we referenced this of just like how interested I am and happy I am when I get to hear Professor Landers, who again is really truly an expert on these issues, opine on them and give her thoughts on some of these really complicated decisions, and makes them accessible, I think, to hopefully most of our listeners out there. I hope people enjoyed it. Certainly feel free to follow up. And Ricky, a lot of our conversations, it's kind of 50-50, or even the interviews are 50-50. And this, I appreciate your patience in letting me ask most of the questions and Professor Landers talk. So I would be curious, are there any thoughts or questions that you still had coming out of that conversation?
No, I mean, to be quite honest, she covers just such a broad variety of the angles of each one of these cases that it's easy for me to sit back, and I feel like she and I are fairly aligned in terms on how we interpret these decisions. So it's actually
yes, I would say that you are.
Yeah. So it's nice that someone much smarter than me can say the things that I wish I could articulate. But I guess, she is your professor after all, and I would love, and I know that, some of these things you agree with and some of them you don't. I guess if you were going to give a kind of a broad rebuttal in defense of this court and kind of how they decide cases and just sort of your overall opinion of them, sort of, yeah, where do you land? Because I know one of your big things, going into some of these appointments, Gorsuch, Barrett, was like, no one's giving them a chance. They have these they have these great resumes. They're very like astute legal minds. Given all that and sort of what a lot of the things that Professor Landers talked about, like how do you feel about this court today?
Yeah, I think throughout most of that conversation, I'm not trying to push back as much because like she is the expert. I really just want to hear what she has to say on it. This isn't like class where my poor classmates would have to listen to me push back on almost every single thing that she said. That's not what we're trying to do here. Look, I think maybe one of our philosophical disagreements, like at least judicially, and it's also probably a similar disagreement that you and I have about some of these things, is what she says at the end there of like, she's super concerned about the practical implications of these decisions, right? She says, like, I don't think that agencies are going to be able to act in a preventative way, or they're not going to be able to make these laws that they think that they should be able to make. And she makes that's a similar argument that she would have kind of across spectrums of constitutional law. She would say that about the admin law cases. She would say that about the gun cases, about the abortion cases, about like, you could hear what continually came up for her was like the burden this might put on individual judges or on the court system as a whole. And what I have long said is that I don't think that the judges should be concerned about things like that. Like their job is to say what the law is and not what the law should be. And so I think she kind of brought up the contrast of like these administrative law agencies not acting. Oh, some people might like that, but I think it's going to leave some things unaddressed. Yeah, I think what these judges are saying and what I think a lot of people policy wise believe in is like there was a problem with these administrative agencies acting as they've been and like far exceeding their authority. And whether that's at the federal level or at state levels, this court is not striking down their ability to do a lot of what they have been doing. And she references FDR, and I know you and I see FDR and his administration really differently. I think for you, he's one of the great presidents in history, and his administration advanced the United States society in a lot of ways. And I think there are really good arguments for that, honestly. But there's a lot of criticism of the judges that blocked a lot of what he was trying to do. I never had a problem with any of those judges either. So I get like that's kind of where I understand her concerns, your concerns. Like, and again, what she's saying, what you're saying is like these decisions affect real people, and really that's what it should be about, right? It's about, we create laws and we create government to protect people and people's lives and interests and those sorts of things. And I don't disagree with that entirely. I am just much more in favor of restraint, and government should be doing less.
Yeah.
And what this, yeah, go on.
No, I mean, I understand that as your like general position as it comes to the law. I think we've talked about this with cases like Roe v. Wade. I think the interesting thing and where you've always sort of landed for me is that if people want these laws, it's not up to the courts to make it for them. They should be coming through the legislature. That's their job. The problem I continually have with this is that what this court is doing is saying, really, we are going to decide what is law and what is not. I think, the cases that we ended with on the Second Amendment, as you, I'm sure you would say, credit to Clarence Thomas, at least he's consistent, right? Like domestic violence not being something that we were really concerned about during the founding of this nation. There was no way that was contemplated as an application for the Second Amendment. It's just it's not possible. But, in their infinite wisdom, they decided here that it applies. I'm glad they did. But then, we didn't talk about the bump stocks case, which effectively turns a semi-automatic rifle into an automatic rifle. and they decided that, well, that's not the exact same thing as a machine gun, so whatever, that's fair game. So this notion that this court is sort of originalist or textualist in a way that it really forces legislators to do their job, I don't think is necessarily true. I feel like this court has very stated goals on certain in certain areas, and when it's convenient for them to be textualist or originalist, they are, and when it's not, they kind of throw it out the window. I'd say the other thing is that they have
hold up. I agree with that. I think that's a really valid criticism. I've been disappointed in the court as a whole that seems to be picking and choosing when we want to go to history and tradition, and when we just kind of want to rely on the specific case that supports our arguments here. And what I think, again, where I feel like we, the royal we, have like won the war is we forced everyone to have like an originalist, a textualist interpretation of it to make the arguments. But I think one thing that has done is you've given Justice Jackson, Justice Sotomayor are like, fine, we're smart enough, even if we don't necessarily agree with that way to interpret the Constitution, we're smart enough to be able to make those arguments and to make them effectively and to point out the inconsistencies in how you're necessarily applying your stated judicial view, which I think is fair. Sorry, you had a second point.
No, I mean, I think that is right. I mean, I think one point is to point out kind of the hypocrisy. The other maybe is to say that the courts here in effect are increasing their power because they are basically saying everything that you want to know, whether it's legal or not, has to come through us, right? The Chevron deference, for instance, 40 years of legal precedent, basically saying that we give the benefit of the doubt to the agency that was created and to their elected, appointed leaders who are subject to, political appointment, right? That those change. As you pointed out, the case was originally decided in favor of Reagan's EPA, which was like, we don't care about the Clean Air Act, so we don't want to do anything about it. And this kind of notion too, that these transactional costs don't have an impact over time. Yeah, I mean, I think like it's a little bit easy using sort of this letter of the law versus the intention of the law argument, because at some point you have to say that individuals deciding intention is not how, as a democratic society, we want to move forward. But when intentionally vague statutes are the law, basically you're taking the power away from an agency and moving it into the hands of a judge, a decidedly less educated judge, to make a decision on a certain topic. So those types of things don't, for me, advance. I don't know. I don't think they advance the intent of the courts, whether it is what I feel like the intent of the court should be today or what the founders envisioned for the courts in the 1700s. And then I don't know. I think Professor Landers talked very eloquently about this kind of destabilizing nature of how the court is going about. And I guess maybe my last question for you is like, what do you feel about the future of stare decisis? Like, do you just throw that out the window, and when you get your political appointees in there, you just start revisiting all court cases and just deciding them however that current panel of 9 justices works out to be?
Yeah, it's tricky. I think this court would say that that's not actually what they've done, right? They've said they've only overturned cases that were unworkable or were wrong as decided, right? And the argument from whether it Alito on abortion or Thomas on guns or whatever, or Roberts on some of these, like the Chevron deference, they were saying like, this is stuff that the court created and it was wrong. So we have an obligation to fix it. I think you astutely point out that there's no reason that a different makeup of the court could say that exact same thing 10 years down the road or 20 years down the road about some of these things. And that is frustrating to me. There's clearly not only a place for stare decisis in our judicial system, but there is like a preeminence for it, right? There's a reason why like stability in the law is super, super important. And so I don't disagree with what I think the arguments of this court would be, where if it was wrong when it was decided, we do have an obligation to fix it, right? It's the only way we overturned Plessy v. Ferguson, right? So like we have to say that there are times where the court made wrong decisions that we should overturn, right? This stare decisis isn't like this immutable characteristic, but given the scale and the pace of kind of discarding stare decisis over these last few years, I think they've opened themselves up to all sorts of arguments on the other side, whether those are judicial arguments or like, all right, once we get our judges in there, we're just going to flip it, or policy arguments of, all right, let's expand the court. I mean, if the judges up there don't have respect for the history and tradition of the court, why should we have kind of respect for how it's been these last 150 years? So yeah, I think you are correct to point it out as an issue.
Yeah, it does. You always remind me of that kind of Harry Reid and McConnell, careful what you wish for type of thing. And this to me feels like that. And one of the, whether it's always been true or not, sort of the perception of the court being above politics just like continues to go down the drain with this particular court. Especially, I mean, like given, and again, maybe this was always the case, but their blatant kind of connections to the former president's administration, like, the upside down flags that Professor Landers talked about, like all of these things just make it so bad. And like the Supreme Court in the United States, like really had this kind of a reputation. Obviously, I was probably more in favor of it because over the last 100 years, most of those decisions might have been going my way. And that I think that's fair to acknowledge that there's some bias in my perception of it. But I mean, I think it would also be difficult to acknowledge that, like, I don't know that the perception of this Supreme Court has ever been lower.
No, it's the same thing we said when we talked about this back in the fall, right? It's one thing if you want to have these judicial philosophies that people out there might disagree with, but when you then pair that with the appearance of impropriety, kind of unambiguously and continuous, like appearances of impropriety, in that you're not actually an unbiased, objective judge when you're making these decisions. Yeah, I think those two things are devastating to the integrity, or at least the perception of integrity of the court.
All right. Well, it was still a very illuminating discussion, despite potentially having a bit of a depressing ending.
Yeah, no, it was great. So thank you again to Professor Landers for coming on and sharing so much of her time and expertise with us. Thank you to everyone that listens. Obviously, you can listen to us wherever you get your podcasts. You can follow us on Instagram at @A_gentlemen's_disagreement. We're on X at Real Gents Pod. So kind of wherever you're out there, you can, or social media on, you can find us and follow us. And we certainly appreciate all of the support.
Definitely. All right. Until next time.
See ya.
What I wouldn't give for the hope I used to find in a case of lion's head. Folks of different minds, because even though it did not share the pain as we share, that American ideal, friends made over arguments in an early morning buzz. Need an early morning buzz.